Hello guys, Assalamu alaikum. My name is Afaq Ahmed Khan. I will be recording lectures for Tort Law. Before going deep into the details about the present chapter of Trespass, let's have an overview of Tort paper. Going towards an overview, let me show an past paper. This is a past paper of Tort Law. I think this is 2023 Zone A. Basically, there are two parts in our Tort Law exam. One is Part A and number second is Part B. In Part A, you will be given a compulsory article before the exam, mainly 2 to 3 months before the exam, and you have to answer certain questions from that article. For example, you might answer 3 questions, or there might be 4 questions. You have to answer those questions in 8 case laws from the article and answer it in merely 7 to 8 sentences each question. Thus, this is Part A, which is compulsory, and not attempting it will cause failure in exam. Now, coming towards our second part, which is Part B, this part deals with our course, which is Tort Law, and I think we are having a total of 18 chapters, and Part B deals with these all 18 chapters. We have a total of 8 questions in our Part B, and out of the 8 questions, we have to only attend 3 questions. Let's check that how many of them are problems and how many of them are essays. Number first is a problem question, 2 problem questions, 3 problem questions, okay, 3 problems and 1 essay, 3 problem and 2 essays, 4 problem and 2 essays, 5 problem and 2 essays, 5 problem and 3 essays. This is the last question. Now look, you have choice either to attempt 3 essays and cover it, and either to attempt 3 problem questions out of 5 problems. What I prefer, that attempting problem questions would gain more marks than essays questions. Now let's go towards our chapters of Tort Law. We have some about 18 chapters in our Tort Law, like ignore number first chapter, which is sources, and number second chapter, which is modern influences. Our real chapters start from Trespass, which is chapter number 3. Then we have negligence, psychiatric harm. Then we have vicarious liability, employer's liability. Then we have defective premises, which is pure economic loss. Moving on, we have defective premises, which is occupier's liability. Moving on, we have nuisance and Ryland versus Fletcher. The question about this chapter, chapter number 16 and chapter number 17, comes in a combined form. And the last chapter is privacy and misuse of information. Coming towards the most important chapters for the problem, if you want to attempt 3 problem questions in Part B, the 3 chapters which I prefer to study are: number first, do study chapter number 3, which we'll be doing now, is trespass to the person and trespass to land. Then the second most important chapter is defective premises, chapter number 15, occupies liability. You can do 2 questions now, and the last chapter to prepare is the law of nuisance and the rule in Ryland versus Fletcher. These 2 important chapters come in a combined form. Thus, we have a total of 3 chapters most important. Moreover, if you have difficulty in either of one chapter, then you can also attempt the question of psychiatric harm or negligence. Coming towards the essay questions, we have the most important essay question, which comes again and again, is regarding the misuse of private information. Okay, the last chapter, which is privacy and misuse of information. This question comes again and again in our past paper exam. Moreover, the chapter number 13, which is regarding vicarious liability, essay questions come from it. You can see that here that the question has been asked here by the examiner. Moreover, we have also pure economic loss. Okay, it is chapter number, let me check what chapter number it is, chapter number 6. And another chapter which is important is employer's liability, which is chapter number 12. Now, first of all, we will attempt problem questions. The first chapter, which is the most important, a problem might come from this, is chapter number 3, which is trespass to person and land. Now, you should keep in mind that there are 2 chapters in one chapter. Okay, two main topics in one chapter. Like one is trespass to land and another is trespass to person. For problem questions, the most important is trespass to person. Question does not come from trespass to land. In about 10 years of past papers, only one question has came from trespass to land, and all other questions were from trespass to person, which means that first we will cover trespass to person in order to have secure a one problem question. Coming towards our lecture, what is trespass to person? What does it mean? First, going towards the definition, trespass to the person is a tort which involves wrongs being done to an individual. Like, ignore this sentence. Come towards here, which involves wrong done to an individual. For example, a fox stands up and he hits B. This means that a fox has done wrong towards B or has done wrong to an individual whose name is B. Thus, a fox can be held liable for trespass offenses, which is known as trespass to person. As I have done, I have hit him with a leg, or I have kicked him, or I have punched him. This means that I have done wrong to that specific individual, which is B. Now, in order to, if B wants to claim that he has done trespass to me, and it includes in trespass to person, there are three requirements. Number first, there should be an intention. An intention shall be proved that a fox had an intention to hit B or hit C. Secondly, the next element, the first is intention. The next important element is direct causal connection. This simply means that the injury or the disturbance caused to B must be only because of my acts. Okay? If there is other intervening factor or other intervening action done by an other individual, thus the direct causal connection will not be intact and it will be broken. As we have studied in our criminal law that a chain of causation will be broken. Thus, it is required that the injuries caused to the second person must be done due to my actions. Thus, it is known as direct causal connection. Moreover, our last element is regarding actionable per se, which is a principle which means that no proof of harm needed. Means that we have to only prove the required intention and a direct causal connection, which means that the injuries caused are due to my actions. Okay, these are the three most important elements. Now, coming towards the paper point of view, in trespass to person question, a problem question, there are three topics which examiner will ask, or there are three main offenses under trespass to person. If you want to attempt a problem question on trespass to person, there will be three situations, either in combined form or either in separate form. These all situations will deal with battery, assault, or false imprisonment. The last one is a bit different concept, and the first two are interlinked with each other. Coming towards our first topic, which is battery, let's define it. What is battery? It is an actual infliction of unlawful force on another person. However, as we studied earlier, that there is no proof of harm needed. The definition is from here to the person. Now look, there are two more main important elements in battery to prove. Number first, there must be an actual infliction. Okay, and number secondly, the force used on other person must be unlawful force. Okay, for example, person A stands up and he kicks person B. Okay, thus he has inflicted an unlawful force on person B, and he could be held liable for battery. More examples are like punching someone, okay, unlawful taking someone's fingerprints, it is also battery. Thus, these are few examples like punching someone, kicking someone with the intention to harm him or to disturb him. Thus, these are covered under battery. Okay, these offenses are known as for battery offenses. Okay, moving on again. Coming towards our elements of battery to prove. There are two more most important elements of battery. If a there is a problem question. Number first situation might deal with battery, so you have to define battery first and then go towards its elements. That now I will go towards the elements of battery, which are that the harm inflicted by person A, you must not write the person A, but also you should write the name of the person mentioned in the problem question. The first element is the harm inflicted must be direct. Number second element is that it must be intentional. Like as we studied again, that what does direct mean? What does the sentence the harm inflicted must be direct mean? I already mentioned it earlier, that the injuries or disturbance or damage done to person B must be due to my actions without any intervening factors. There must not be any intervening factor between these two, which means that the injuries caused to person B must be due to my actions. Okay. Now let's see the definition of direct. That direct harm refers to immediate or clear damage or injury caused by an action or event without any intervening factors. You have to prove that the B cause, for example, a situation comes, you have to prove that the harm done to B is direct inflicted harm, as because if A did not acted, or if A did not punch B, he would not have get injured, or he did not have got any damage, which means that it is direct inflicted harm. Now coming towards, in simple terms, this means that let me check our recording is going on. Yes. In simple term, direct means it is a result of the defendant actions. It is the result of a Fox action. It is the result of any B person actions which is injuring or which is causing damage to person B. We have two cases here. First case is Purcell versus Horn, 1838, and another case is Haysted versus Chief Constable of Derbyshire, 2000. The ratio of these both cases is same. Both cases state that indirect contact can fulfill the requirement of direct application. Okay, now as we studied that the harm caused to the other person must be direct. Now there is an exception to that rule. That exception is that indirect contact can fulfill the requirement of direct application. Moreover, the Haysted case tells that the defendant was held liable, but although physical force applied by me had not been directly applied. Okay, let's answer these two cases with the help of an example. Coming towards an example, okay, this is an example. Look, there is one man which is attacking person B, and person B is holding a baby in his hand. Now imagine that person A attacks person B. During that attack, person B accidentally drops the baby, and this causes some injuries to the baby. Now, even though, simple meaning, the attack was towards person A, and person A could not, person B, sorry, and person A cannot be held liable for the injuries towards the baby. Like, he did not attack the baby, he attacked the person B. Okay, but not here. In the direct situation, as we studied in our case laws, that indirect contact can fulfill the requirement of direct application. Applying this case here in this example, in this situation, person A did not directly attack the baby. However, the injuries caused to the baby were the result of the actions of person A. Like, going reverse, if person A did not attack person B, the baby would not have been injured. Thus, person A could be held liable for person B, as according to the case of Purcell and Haysted, here the indirect contact of person A fulfills the requirement of direct application. Okay. Now, moving on towards our second element, as we studied, the first element is that the harm must be direct. Then we studied exception to this, and we studied that there must be a clear damage. Then we studied two cases with an exception, with an example, and applied that specific case to the example of person A attacking person B. Now, coming towards our second element, which is intention. This is the most important element to prove, and if you don't prove this element and skip it, you won't get marks for this problem question. The element is that there must be an intention. Okay, there must be an intention to cause damage or to cause interference or to cause disturbance. Okay, if there is no intention carried out by a person, thus there will be no liability. If the actions of person A are due to an omission, thus he could not be liable. For example, let's say example, there are two people standing. One is person A and one is person B. Person A is hit by a truck from the back and he falls on person B, and person B gets some injuries. Now, whether person A would be liable for the injuries of person B or not. Like, the actions were direct, but is there any intention? Coming towards the intention of person A, he wasn't having any intention. This was caused by an accident of the bus. Thus, there is no intention of person B to cause damage to or to cause injury to person B. Thus, there will be no liability. As without intention, without having an intention, there could be no liability and to cause the interference. Okay. Now, there is also another important point that, however, you need to know of the likely consequences of the actions, which means that if you sleep on your acts, you act in a way that you must know that what will happen from my act. Okay, you must know the consequences of this act. If you ignore those consequences, you will be held liable for that. Moreover, the actions must be voluntary. As I already mentioned an example of the bus, the actions of person A weren't voluntary. Those were involuntary and those were out of his control. Thus, he could not be liable for that. Coming towards the case of REF, and according to this case, battery constituted any intentional physical contact that was not generally accepted in the ordinary conduct of daily life. This somehow deals with intention elements. Like, for example, in a bus, passengers are traveling. Bus accidentally stops, and the passengers touches each other shoulders, and they, for example, they had a type of physical contact between the passenger occurs. Whether these, for example, we have two passengers there and their physical contact with each other due to the brake of the bus, whether person A would be held liable towards person B of the physical contact. Applying the case of REF, the brakes in the bus and the physical contact that happens between the passengers in the bus is already covered in our ordinary conduct of life. This happens usually in the buses. Thus, person A wouldn't have been liable. He could claim that this is the ordinary conduct of life. Coming towards another important case, which is Rickson versus Starr, 2001. In this case, it is stated that if it is done to get the plaintiff attention and was in the ambit of daily life conduct, then acceptable. Okay. Now, this case means that, let me give an example. Two colleagues are working in an office. Colleague A comes towards colleague B and taps on his shoulder. Whether, according to the Rickson case, colleague A would be liable for the physical contact with person B or not. Applying the Rickson case of Starr 2001, colleague A just came and tapped person B on his shoulder in order to get the attention of person B, and this was this covers in the ambit of our daily life conduct. It is acceptable that we tap shoulders of each other. Thus, he could not be held liable for the battery. However, if person A comes in a hostile mood and punches him on the back or kicks him on the back, then we can claim the case of Rickson that it wasn't done in order to get the plaintiff attention. It was done in a hostile mood and it is outside the ambit of our daily life. Thus, it is not acceptable and the colleague A would be held liable for the offense of battery. I hope you understood this concept. So far, we have studied battery. Okay, we also studied that it is an actual infliction of unlawful force on another person. We studied that there is no proof of injury required, which is actionable per se principle. And we also studied some examples. Then we studied that there are few requirements to prove battery, which is direct contact. And there is an exceptions to the direct contact if your actions led to the injury of person B. Now, then we studied intentional element, okay, and we studied the case of REF. We also studied Rickson case. Then let's go towards our second most important topic. Like I already mentioned, that a problem question will come and it will cover these three important topics, which is battery, assault, and false imprisonment. Okay, when a problem question appears, it will have these three topics covered in that. Coming towards assault, let's have a definition of assault. According to the case of Collins versus Wilcock, you should note this case, and before coming towards battery, you should define that according to the case of Collins versus Wilcock, Golf LJ defined assault as brackets, and you should state that an act which causes another person to apprehend. The first most important element, apprehend. Okay, the infliction of immediate, which is the most important one, unlawful force on his person. For example, this is now this definition, like we studied that an act which causes another person to apprehend the infliction of immediate unlawful force on his person. This definition simply means that attempt made by person A to threat or to harm a person B. Okay, and that act must be done intentionally, it must be done indirectly. The elements are same as for the battery, and that act should cause C to apprehend immediate battery. He should realize that, oh, person A is coming and going to hit me. Okay, he should realize that. If he could not apprehend immediate battery, then he won't be liable for assault. Perfect. For example, in a situation where I'm having, for example, consider this is as a stone, okay, and I am traveling in a train. Okay, person A picks up the stone and he does like this. Okay, now the actions is that it is whether the stone would hit me or not. Here, the requirement of immediate inflection cannot be satisfied. Just because I cannot apprehend immediate battery, that stone won't reach me. Thus, the person who is having the stone would not be held liable for assault just because of the simple element of immediate battery. As it is not satisfied, the stone cannot reach the bus, thus I cannot get battery. Perfect. Coming towards the requirements of assault, the first requirement is intention. Number second requirement of reasonableness of fear, and the third requirement, as I mentioned, that the assault must be done and a person should apprehend immediate battery. Okay, this is the most important element. Let me go before doing this example. Let's finish the requirements and then we will have a difference between assault and battery with an example. Okay, coming towards our first element, which is intention. Okay, note it there. What should be the intention of person A? The simple, and in person the battery we studied that there should be an intention to cause disturbance. However, in assault, the intention should be that person A wants to cause fear towards person B, or person A wants to threaten person B. Okay, this is the intention. Also, the case of R versus Ireland, words and threats can also amount to assault. Like, for example, going towards intention, again, intention to cause fear. I stand up and I go towards, in a hostile mood, go towards person B, and I am having a knife in my hand and I state that I will kill you. And my gesture suggests that I'm causing fear to person B, and he is having immediate, he might have immediate battery. Thus, here the intention element is proved. Coming towards I versus Ireland case, which is that words and threats can also amount to assault if accompanied by threatening gestures. I stated that let's person A is going towards person B and he is moving in a way that he will kick him or he will punch him, and he is speaking those words, putting those words or threats, which means that he might hit him. Thus, those gestures accompanied with words and threats might amount to assault. Coming towards our second factor, which is, or element, you can also call it element, which is reasonableness of fear. According to the R versus George case, but this must be noted by you. A reasonable person in the victim position would have thought that there was danger. Okay, I gave an example. For example, um, there is a mental ill person, and you go towards him, and he believes that you are going to punch me. However, if there was any other reasonable person in his place, and he wouldn't have believed that Afaq would punch me, thus the element of reasonableness of fear is unproved. Just because in case of that person, a reasonable person must believe that Afaq is coming and he would cause assault, or he would cause battery. Okay, there must be a reasonableness of fear. You can also note this case. This is very important. Harvard is Judge 1840. Underline this case. Okay. Coming towards the most important element, which is touched by the examiners in the exam point of view again and again. Sometimes a problem question stuck here in this process, in this element, which is the immediate nature. Let's see that what does immediate nature means. In simple terms, according you can state that according to Thomas 1986 case, there must be an immediate danger of battery. Immediate nature means that I gave an example of a stone and a train was moving and I'm going to hit that person. Now the person, or reasonably, it must be that according to the case, it must be believed that a fog stone will reach towards the train and there is an immediate danger of battery. Okay, if there isn't immediate nature of the battery, and a normal person would consider that the fog stone wouldn't reach the train, thus there is no immediate danger of battery or any harm. Thus the immediate nature isn't fulfilled and there is no assault. The cases of the ratio of these both cases are same. Okay, same as again there, the battery or the violence should be of immediate nature. Coming towards important point regarding the assault point of view is that the threat that the victim believes that a defendant cannot carry out will not constitute assault. Again, the train example, a thought he has a stone and he is going to hit that train and train is moving. Whether the person on the train believes that he would constitute assault or not, he would hit me or not, the person on the train knows that the stone cannot reach me. Thus, he cannot claim that a FARC has caused assault or a FARC has done assault. Okay, this is the most important element. We studied the most important number first. We studied battery, then we studied assault, and now let me give an overview of assault. We studied the definition of assault, which was given by Collins versus Wilcox case, and defined by Golf LJ. He defined the assault. Then he also stated that assault, in simple terms, it means that an attempt to threat or to cause harm to another person. Then we studied that the elements of two elements of the assault and battery are same, which means that there must be an intention to cause fear to the second person, and there must be a direct contact. We also studied that the force used must be of immediate nature, or there must be an immediate nature or immediate threat of battery towards the person, and there must be a reasonableness of fear. Now, if you want to attempt a problem question on like if you're going to attempt a problem question on number first on, let's go towards battery. If you want to attempt a problem question on battery, you have to first define battery, then you have to define what is the intention, then go towards the first element, which is direct application of force. Okay, then conclude it that whether these two elements of intention and directness are fulfilled. If fulfilled, then conclude it. Okay, and then we will also write defenses, but you should write it after we cover it. Okay, then if you want to second question on assault, you have to first define definition of assault, which is given by the case of Wilcox. Then you have to separate each element. Number first, you have to define intention. Number second, you have to define direct act, that the act of A must be direct. Number third, reasonableness of fear. Number four, you have to define according to the facts, the immediate nature of the battery, and at the end you have to conclude it, and you should also write any defenses available, which will be studied later. Now, Coming towards the most and the third scenario, which a problem question will deal. Like first, in the problem question, there will be three scenarios, and the first might deal with a battery, the second might deal with assault, and the third might deal with false imprisonment. This might be jumbled up. False imprisonment might come first, and the battery might come second, and assault might come third. Okay. Now coming towards an important another topic, which is false imprisonment. Let's study false imprisonment according to the definition. It is the total, intentional, and unlawful constraint on freedom of movement of another person, but it does not require captivity or the use of force. Like the term suggests that, oh, a fuck will come and he will use force and he will kidnap me and he will imprison me. No, here is the situation is different. Here there is no requirement of captivity or the use of force. Okay, what are the elements then? There must be number first total. This is the first element. Intentional. In all three of the topics, battery, assault, and false imprisonment, intention is important. Number second, unlawful constraint on freedom of movement. Now check how many elements. Number first, total constraint on freedom of movement, intentional constraint on freedom of movement, and unlawful constraint of on freedom of movement. These are the three most important elements of false imprisonment. Now, according to the Murray case, this is the Murray case. You should note it. As long as the circumstances of the false imprisonment exist. What are the circumstances? That there's a total, intentional, unlawful constraint on freedom of movement. All these elements are fulfilled. The victim does not need to be even aware that they are being falsely imprisoned. A FARC does not need to know that a person B is totally intentionally unlawful constraining his right of freedom of movement. There is no need to know that a FARC, the person is going to be falsely imprisoned. Coming towards the requirements, as we studied in upper, that there must be total, intentional, and unlawful constraint on the freedom of movement. Now, let's study it separately. Number first requirement is that there must be total loss of the freedom of movement. Okay, this is the first requirement. Second, that the loss of the freedom of movement must be intentional, and there should be unlawful constraint on the freedom of movement. These are the three most important elements. Coming towards our first element, which is regarding total loss of freedom. According to the Birds versus Jones 1845 case, false imprisonment is the total loss of freedom and a total constraint of liberty of a person and not a partial obstruction of his will. Okay, what does simply this case mean, or what does simply total loss of freedom mean? Come towards this example. Okay, this is a washroom. A FARC tells person A that my mobile is I have lost my mobile in the washroom. Kindly go and search there. As person B enters the washroom, a FARC locks at that door of the washroom from outside. Now, the situation suggests that a FARC will be held liable for false imprisonment. That's because that he has caused the intentional and unlawful constraint on the freedom of movement of the person in the washroom. Okay. Now, the third element, the total loss of freedom. Let's add another factor into the washroom factor. For example, a FARC has the chance, the person in the washroom has the chance to open, and he has the keys to open the washroom door from the inside. Now, this element, whether the total loss of freedom will be fulfilled or not. According to the Birds versus Jones cases, of the person inside the washroom is having the key, he can open the door of the washroom. Thus, there is no total loss of freedom on his movement, and a FARC wouldn't be held liable for false imprisonment. I hope that you have understood this example. Coming towards Robinson case, if there is a reasonable condition, so the detention would not be complete and false imprisonment will fail. Okay, this must be noted. Coming towards a second most important element, which is intentional. The false imprisonment might be done intentional or negligently. Negligently means that you are ignoring the consequences of your act. Okay. Coming towards this, okay, Iqbal versus prison 2009. False imprisonment will only apply where the imprisonment was caused by the defendant acts and not where it was caused by omission to act. Okay, it must be caused. For example, a FARC uh, actions, a FARC mistakenly or he did not act it to open the door washroom and wasn't locked by him. Whether a FARC would be liable for that, according to the Iqbal versus prison case, if a FARC that action was caused due to omission or to act by a FARC, then he wouldn't be liable for false imprisonment. Again, we studied that knowledge of restraint is not necessary. You can put this case, most important one. Coming towards another most important element, which is unlawful, that the constraint on the freedom of movement of the specific person must be unlawful. Okay, like for example, if police comes and arrests me, it is a total constraint on my freedom of movement. But whether the element of unlawful is satisfied or not, no. Police has the authority to arrest you. Okay, coming towards the Austin case 2009, the acts of the police in order to restrain someone in particular circumstances is lawful, as I mentioned it. Then coming towards Queensland, for example, if courts gives the order to police or the courts give orders that go and arrest a FARC, now the two elements are fulfilled, that there is a total constraint on my freedom and it is intentional. However, is it unlawful or not? According to the Queensland case, detention is justified if it's carried out under an order of the court. Thus, a person who is arresting me on the order of the court wouldn't be held liable. Okay, thus we have studied three most important topics, which is false imprisonment. We studied that there must be total loss of freedom, it must be intentional, and at last the intention and all that stopping my all those actions which are stopping my freedom to movement must be unlawful. In case police is arresting me or it is done on the order of the court, then it would be lawful. But the important factor in which the examiner mostly asks is the total loss of freedom. Okay, you must guess that whether the person who is being imprisoned or whose rights are being violated, whether he has the chance to get escaped or not. If he has the chance to escape from the false imprisonment, then there is the element of total loss of freedom isn't satisfied, and the person A wouldn't be held liable for false imprisonment. Okay, coming towards the defenses to trespass to person, and basically after proving all the elements of these three topics, you have to add specific defense to each one. Now, basically, there are three defenses available in these all offenses. Number first is consent, which is the most used. The second is self-defense. Again, this is the most used. And the third is necessity, used in not much likely. Okay. So three defenses to trespass to person. After proving all the elements of the three offenses of battery, assault, and false imprisonment, you have to add any applicable offense defense to that specific offense at the end after conclusion. Like you will state that the person is held for battery, however there is a defense of consent available, and then you have to prove it. Coming towards the consent defense, according to the Chester versus Afshar case, doctor failing to say all risk does not negate consent. For example, I go to a hospital and I consent for my surgery. However, the doctor does not tell me about all the risks of that surgery. Thus, the doctor wouldn't be liable for battery or for assault. Okay, we can apply the case of Chester versus Afshar, that if the doctor fails to tell me all of the consequences or all of the risks associated with my surgery, this does not negate consent. The consent is still present. Moreover, in like for example, sports matches, we play sports like fighting matches or football or cricket. We consent towards those matches before the competition, and is implied consent, which is according to the case of Billinghurst versus 1979. According to that case, that implied consent during sport matches can be used as a defense according to the case. Okay. Coming towards the case of Lanarkshire, again important case, This is the Nashai case states that the consent might be vitiated by fraud if the defendant withheld certain information in bad faith. For example, doctor tells person B that, and the doctor has knows that it would cause injuries toward person B, and he does not tell person B that this surgery would cause injuries to you, just because the doctor wants those injuries to that person. Thus, here the consent would be vitiated just by the fraud, just because the doctor had a bad faith. He did not told and all of the risks to that specific person. Already the doctor knew of it, just because he wanted that the injuries must be consented by to that specific person. So two situations, like in one situation, the doctor isn't having any bad faith and he fails to say always, it does not negate consent. But according to the Lanakshai case, if in a bad faith, the doctor or the consent might be vitiated if the defendant withheld certain information in bad faith. The most important element is bad faith. Coming towards our second defense, which is necessity. When a defendant acts to avoid a greater harm to the claimant, specifically means that, for example, Afaq has done accident and Afaq is taken to the hospital. Now, Afaq is unconscious. Whether the doctor is doing his surgery or doing his treatment, and in that treatment, Afaq dies or something happens to Afaq, which defense would the doctors use? The doctors would use the defense of necessity in case the doctors are held liable for battery, just because that doctors had authority to do his surgery, just because he was found unconscious due to accident or illness. However, there is an exception to this also. What is the exception is given by the case of REF 1990. The case tells that the treatment must be well recommended by a responsible doctor and in the best interest of the patient. For example, there is simple stitching required to that specific individual who has done accident. However, the doctor does his surgery. Whether that treatment is in the best interest of the patient, no. Then the doctor might be held liable for battery. However, if the surgery is required and another reasonable doctor, responsible doctor, would also recommend that surgery, and that surgery in this is the best interest of the patient, then according to the Bolam 1957 case, a doctor can use the necessary defense just because it was his duty and the person was found unconscious due to accident or illness. Coming towards our last defense, which is self-defense, it will be a justification for the offense of a battery if the force used was reasonable and proportionate to the threat. For example, Afaq is going towards A with the harmful gestures, and Afaq is having a knife. Before Afaq uses the knife, another person, Ali, who is being attacked, comes in a speedy way, and he is also having a knife in his pocket, and he gets that pocket in order to protect himself from the attack of Afaq. He stabs Afaq in his stomach. Whether Ali would be liable for that thing or not, or the specific offense of battery or not. Here in this situation, we look into two important elements: what is reasonable and the other proportionate. Whether the force used by Ali was reasonable or not, whether Ali had any other option in order to protect himself from Afaq or not. If he had another option, then he would be held liable for battery. Moreover, the force used must be proportionate. For example, if you can stop with the help of your hands and you use your knife instead of that, then you cannot use this defense. The second element would not be proved. So up till now, we have studied important elements: battery, assault, and necessity. At the start, I told that two important topics in this chapter, which is first is trespass to land, and the second is trespass to person. The trespass, all of the problem will come from the trespass to person. However, let's also check what is trespass to land. Normally, coming to the second half of the lecture, let me open a Microsoft Word and write this definition. Okay. The second topic is trespass to land. I hope it will be visible now. Yes, it will be visible, inshallah. Ignore the spelling mistakes, please. Okay, what is trespass to land? It means that entering unlawfully, first element, upon another person land or unjustifiable interference with the possession of the land. Now, there are two most important elements. Number first, entering someone's land unlawfully, okay, or unjustified interference with the possession of the land. For example, I enter someone's land without any permission, without any license, and I'm causing damage towards their belongings. Thus, it would be trespass to land. Two important elements. Number first is the direct unlawful interference. Okay, there must be unlawful interference to the land. Number secondly, it must be intentional. Okay, the second important element. And the interference which I am causing, interference must be voluntary, which means that it should be in my control. Moreover, the next important element is that it is actionable per se offense. Like we studied already, that it is not required to prove that whether harm has been done or not. Okay. Now, another most important element, that no need for awareness that trespass is occurring. If you are entering someone's land by mistake, you would be held liable for the trespass to land. So there are three most important elements to trespass to land. Number first is that there must be direct interference. The direct interference is given by the case of, let me write the case for you. Notice direct interference cases Gregory v. Pipper, 1829. Okay. Then it must be voluntary. The voluntary element, you can use the case of Stone versus Smith, okay, 1947. Okay, if the defendant is brought to the lane, for example, if I am taking a fog towards the defendant lane and I'm pushing him, then he wouldn't be liable just because his actions of a fog weren't voluntary. You can use this case. Moving on, awareness is not necessary if the trespass is caused by a mistake. Thus, it would be trespass to land. You can use the case of interference must be voluntary. Awareness is not necessary. Here you can use the case of Conway. Okay, Conway 1951, important case. Moreover, as we studied that there is no harm required. However, let's define land that as the trespass is done towards the land. So what is land? It includes surface and anything permanently, okay, permanently attached to the land, like houses, walls, or standing crops. Like any land or any surface or anything which is attached to the land, like houses, walls, etc., is known as land. Okay, now who can bring the claim of trespass to land, that a FARC has trespassed my land? Who can bring this claim? Who can bring the claim? Someone having possession of the land, the person who is having control of the land. Okay. Secondly, someone having exclusive possession or having a title of the land, or the title is registered. Okay, he's the owner of the land. And secondly, we can use the case of Nichols. In this case states that it is essential to be in possession of the land to sue in trespass. If you want to sue a FARC for the trespass, the most important element that you should define first land, that does the place where a FARC is trespassing is covered in the ambit of land or not. If it is covered in the land of ambit of land, then I have to prove that whether I am having a possession of the land, and whether I am having control or not. You can use the case of Nichols, that according to Nichols' case, I'm having the possession, thus I can sue for the trespass. Here we are done with two most important topics, which is number first was trespass to land, and second was trespass to person. For your exam point of view, the most important one is trespass to person. Okay, you should scenario will come covering all these offenses, or known as one scenario will be there which will cover all these offenses. Thus, after studying these three, one problem question will be solved easily. Thank you all, and in our second lecture for this chapter, we will solve a problem question. We will study an overview of how to attempt that problem question step by step, and I will also share an overview of the problem which I have attempted. Okay, thank you so much all guys for attending the lecture.